Welcome to Legal Clarity, the podcast brought to you by Hatch Brenner Solicitors. Join us as we explore legal insights, real case studies, and personal stories that aim to both inform and empower. In this episode, Dispute Resolution Solicitor Janet Lane sheds light on a vital topic: understanding Inheritance Act claims. She'll explain who can bring a claim under the Inheritance Act of 1975, what factors the court considers when deciding if reasonable financial provision has been made, the strict time limits involved in making a claim, and how claims can often be resolved through negotiation rather than going to court. If you're facing uncertainty after a loved one's death or believe you've been left without reasonable provision, this episode offers clear, expert guidance to help you understand your rights.
So Janet, who can claim under the Inheritance Act?
The Inheritance Act sets out specific categories of applicants, which are a surviving spouse, and this includes a judicially separated spouse or a civil partner, a party to a voidable marriage that was not annulled before the testator died, and persons who have entered into a polygamous marriage. It does not include a person who has been a party to a ceremony that does not amount to a marriage in accordance with the law of England and Wales. So you've got surviving spouse, then there's former spouse, provided that at the date of the testator's death the claimant hadn't remarried and the marriage was during the testator's lifetime and either dissolved or annulled by a decree or divorce granted in the UK. Next category is a cohabitant. They have to have been living with the testator as husband and wife or civil partner, living in the same household, and for 2 years immediately prior to the testator's death. And then we have the category of a child of the testator, which includes adopted or illegitimate children, and a child conceived before the testator's died but born after the death. Then we move on to a child of the family, and this claimant must show that they've been treated as a child of the family in relation to a marriage or a civil partnership between the testator and another person. It doesn't apply if there was no marriage. And then finally, a person treated as a dependent of the deceased. And this is a catch-all really to enable anybody who doesn't fall within the other categories or can't establish a relationship to make a claim under the other categories. And they can claim provided they can show that immediately before the testator died, they were being wholly or partly maintained by the deceased.
What factors does the court consider?
There are 7 main factors. Factor 1 is the financial needs and resources that the applicant has or is likely to have in the future. 2, financial needs and resources which any other applicant has or is likely to have in the foreseeable future. 3, financial needs and resources of any beneficiary of the estate or the deceased has or is likely to have in the foreseeable future. 4, any obligations and responsibilities the deceased had towards any applicant towards any beneficiary of the estate. 5, the size and nature of the net estate of the deceased. 6, any physical or mental disability of the applicant or any beneficiary of the estate. And finally, 7, any other matter, including the conduct of the applicant or any other person that in the circumstances of the actual case the court might consider relevant.
What are the time limits for making a claim?
The time limits are very strict in bringing Inheritance Act claims and short. The claim has to be brought before the end of 6 months of the issuing of the grant of representation, so that's like a grant of probate or letters of administration, so the claim has to be brought before the end of 6 months from the day the grant was issued. The claimant can apply for permission to bring the claim out of time, but obviously that's not advisable. If there's an application for permission to bring a claim out of time, the court must consider, amongst other things, would it be just and proper to grant permission, and how promptly after the time limit is expired, and in what circumstances did the claimant seek permission? Was the defendant on notice of the claim? Did negotiations take place before the time limit expired? Had the estate already been distributed, and the effect on the beneficiaries if permission is granted? And finally, the court will look at if permission were refused, would the claimant have a claim against anybody else, such as a claim against a solicitor for failing to advise them to bring a claim. Obviously, it's best not to deal with the matter to the expiry of limitation. There can be agreement to extend limitation, and this should always be looked at a very, very early stage.
How do you negotiate a settlement without going to court?
As in any other claim, there is always an opportunity for trying to seek to settle a matter without the need for court proceedings. But in Inheritance Act claims, because of the very short time limit, it means that sometimes it's not possible to reach an agreement before proceedings have to be issued to protect the claim. Better outcomes can be negotiated rather than an order made by the courts, and therefore this needs to be looked at as soon as it becomes clear that there may be a claim against the estate. There can be negotiations to delay the obtaining a grant so that the time limit doesn't start running. And also there is the availability of what we call standstill agreements, which means that the defendant party will agree not to issue proceedings during a specific period of time. And time stands still, and what effectively the defendant is doing is agreeing not to raise the issue of the expiry of limitation as a defence.
Thank you for listening to Legal Clarity, a podcast brought to you by Hatch Brenner Solicitors. For more information, make sure to check out our website www.hatchbrenner.co.uk.